it's needed. So, all right. Well, good afternoon. My name is Kathy Keimer. I am a nurse consultant with Risk Management Solutions. Here to provide you an education on legal issues in nursing. You will receive 1.25 contact hours for the education. All I need you to do is fill out an evaluation form afterwards. Of course, it's not for the video, only for live attendance. So today we're going to talk about some legal issues in nursing. You do have a handout that has a lot of good information included in it. I will try to follow it as best as I can, slide by slide, but usually I like to have a discussion, so I kind of jump all over the place, but I apologize for that ahead of time. I myself have been a nurse since 1988, so the rules, the regulations, I have seen some changes throughout the years, but for the most part, our Nurse Practice Act in the state of Ohio is fairly consistent. There's not many changes that have occurred, and when changes do come about, they're usually publicly announced. So just to let you know that is the Nurse Practice Act. Each state has their own Nurse Practice Act in which they outline the rules and regulations of what a nurse can and cannot do and what the expectations of them. Now, each state tends to mirror one another, but the rules can change. The rules can be different from state to state. For instance, in the state of Indiana, you don't have to have contact hours in order to maintain your licensure. So there's not a requirement. In the state of Ohio, of course, you know that we have to have 24 hours of continuing education every renewal period. And one of those hours has to be on the law, the Ohio law, the Nurse Practice Act. So, I always thought, it was interesting as to why, is that the requirement, the law? Because it doesn't change very often. What I have learned, though, is in the position that I'm in now, as far as being a consultant and looking at litigation concerns and regulatory compliance concerns and all of those kind of things, I realize that the rules are black and white. They say what you can and cannot do. Unfortunately, as we practice every day, there are nurses that tend to start having some gray areas. So I think it is beneficial that every 2 years we kind of be reminded of what the do's and don'ts of what we should and shouldn't be doing. So that's what we're going to do today, is just kind of hit the highlights of the do's and the don'ts and making sure that we maintain compliance to keep our licensure. The Ohio Board of Nursing is the division of law that is the administrative law. They fall under that category. So they have the rules and the regulations, and they are the authority. They are the ones that can enforce it. The whole mission of the Ohio Board of Nursing is to actively promote and protect the health of the citizens of Ohio through the safe and effective practice of nursing as defined by the law. So it is their obligation to make sure that every citizen of Ohio is receiving care and services by a competent individual, safe practice. So they're the ones that review our rules and regulations and make addendums if needed, or define them. And I think the one thing that we've seen the most changes is in IV therapy, as to what LPNs can and cannot do. When I graduated in '98, the LPNs weren't allowed to touch them. There was nothing that they're allowed to touch through that. And of course now, as long as an LPN, if you're IV certified, it's advancing because of the practicality of it, of what their training has provided, that they participate more with the IV therapy. So that's kind of one of the examples. They also are the one that controls entry into our practice. They're the ones that kind of say when you apply for your, to take your boards, they're the ones that say, based on certain criteria, if you can enter, even sit for the boards. Again, I refer back to 88, we didn't go through as many, what I would say, hoops to go through for sitting with the boards. Now is, you have to be, you graduate from a, accredited nursing program is what it was in 1988. Now it's also, they also do background information, criminal background checks on each individual, and certain misdemeanors, felonies, or whatever, you cannot even sit for your board. So they do control that. They also are required to do all the discipline of our colleagues. So they're the ones that are in charge of this. If a complaint comes to through them, through the Ohio Board of Nursing, any complaint on a nurse, and they also regulate dialysis technicians now. And of course nurse practitioners and that, but any complaint that goes to them, they are required to investigate each and every complaint that comes through. We'll talk a little bit longer about what is the mandatory requirement to the Ohio Board of Nursing, but so by all of their complaints upon investigation, if they feel that it's necessary to discipline, they have the authority to discipline each individual nurse as they see fit. Now, of course, it's not one person on the Board of Nursing, there's 12 of them. So there's an equal representative, and there is also a consumer, a person that doesn't have any nursing background that sits on the board so that they can be that, I guess, non-partisan kind of thing, so that they can see it from the public's point of view. The one, so there are 4 different sources of law, and I'm only, like I said, I've kind of explained the administrative law where the Ohio Board of Nursing fits in. The other source of law, which I think is where we want to focus on, is what they call the judicial law. This is the law that is the courts. You have the judge and the jury, and this is where most malpractice suits are conducted, are listened to and tried, and a decision is made. When, as nurses, for our liability, our professional practice, historically, like I said, I keep referring, and I'm not that old, but 1988, that's almost 30 years of practicing as a nurse. And we have seen so many changes. Historically, the physician was the one that was held most responsible for the resident's care because they were the director. They're the ones that were overseeing it. And so when there was a disgruntled family or resident or somebody that was unhappy with the care, the threat of a lawsuit always went to them. And they were the ones that were held responsible. As we have progressed in our nursing profession, as we have demanded as nurses to be recognized for what we do, recognized for our profession and our involvement in resident care. We are an integral part. No matter what industry you're in, we hold a critical component of the delivery of care for our residents, the overseeing of their care. Well, with that accountability and our recognition of our profession comes also then the responsibility that, okay, if you want to be recognized for the things that you're doing and you say that you play an integral part, then again, you individually can then be held responsible for that care if you do not deliver safe care. So we kind of had, can't have your cake and eat it too. We want to be recognized, but so the ramifications is that we are seeing more and more nurses be individually sued. So it's just something to keep in the back of our minds. And I think as we have become a very litigious society with our economy the way it is, typically when there's a poor economy, you will see more lawsuits. People want the quick money. You also, because of the internet, because of, which I think exposes the public is well informed of what the expectations are from a nursing perspective, from a regulatory perspective, because it's right there at the touch of your fingertips, right? You can see everything. Oh, but they're supposed to be doing this, they're supposed to be doing that. So with that public knowledge means that you're under more scrutiny. So what I want to do is just try to help you and help so that we minimize our chances of having a lawsuit against our professional practice. So typically it's called negligence. In most of the common allegations for nursing malpractice or negligence has to do with failing to follow the nursing process in one aspect or another. We're failing to assess a resident's condition and based on that assessment, develop a care plan for their specific needs. You can be talking about pressure areas, you can be talking about falls, you can be talking about pain and suffering, their pain. So all of that goes in hands with observation because it's our expectation that when a person comes into our building, they are establishing a contract with us. They are establishing that I cannot live alone, I can't be out there, I have to be here for whatever need they might have. And it's up to us to be able to identify that need through our assessment and observation process. Develop then a care plan. Right? Part of the care plan then is that we can't stop there. The care plan then needs to be implemented. Interventions need to be implemented. And those interventions have to be according to the current standard of practice. All right? I mean, we can't be doing anything we want to do. Like I said, for me, pressure ulcers, when I was taught pressure ulcers, we treated them with heat lamp, some Dakin solution, some lamb's wool, egg crate mattresses, things like that. Some of that is obsolete now, but that was the current standard of practice at the time. Now we have different agencies like the National Pressure Ulcer Advisory Panel that actually is what they call the expert. So everybody goes to them to say, what is the current standard of practice and how should we be operating? You also have the CDC for infection control. You have, so you have nursing associations that are participating into what the current standard of care is. So when you talk about your plan of care, it has to be according to current standards of practice. Those interventions then need to be implemented 24/7. We'll talk a little bit about supervision and delegation a little bit later. The other thing is going back in and that, so we have the assessment process, we have the planning process, we have the implementation of our interventions. Most of the time where we let down our guard or we fail in that nursing process is to do the evaluation component. We have to continually evaluate, monitor the resident to ensure that our plan of care is effective or not. And the expectation is that the plan of care is not effective, we have to do something about it. So when you see the allegations it's related to patient falls. It's relation to failure to monitor the resident, failure to make sure that we have a safe environment for our resident, failure to provide the necessary care, like the interventions weren't implemented 24/7. The other component too is your medication and treatment administration that tends to hold up a lot of your time. But that's also a critical component is knowing with medications and treatments, again, what is the expectation when you're administering medications and treatments? It's it's the same principles as the nursing process. When you're giving a medication, you have to do the same things. Assessment and observation. Know what that medication is for. Know why it's being used. What's the benefits of the medication? What are the side effects of that medication? And you need to know that before you administer the medication. And then, once that medication is administered, to make sure that we are monitoring the effectiveness. We're monitoring for side effects. And if we fail in any of those components, it's an opportunity for potential negligence to occur or be cited. So keep that in mind also. Looking at negligence, looking at malpractice, there's what I call two different types. One is unintentional. It means we did not intend to harm this patient. We really felt we were operating in the best interest of this resident. We really feel we assessed and observed this resident. We feel that we put everything in place, but harm still occurred. So that's the unintentional. Intentional, unfortunately, there are still intentional malpractice and negligence, and most of them fall into the abuse category. Is you're willingly, you're knowingly either physically abusing someone, verbally abusing someone, sexually abusing someone, misappropriation of their property. I mean, that's a knowing intent that you know that you're taking something away or that you are doing harm. So that's part of also where we kind of define a little bit, is to looking at where does this fall, what category does this fall into? Did you willingly withdraw treatment and knew it was going to cause harm? You know, or did you knew that by not giving a Vicodin for a patient that's in pain, you knew that by withholding that person's pain was not going to be relieved. That's intentional, that's willful, okay? So you kind of watch that a little bit. When you're looking at it, you're going to, before a charge can become against you, before someone can say that you were negligent or being sued for malpractice, there's some criteria that have to exist. 5 criteria. The first one is that there is a duty, whether it is written or implied, to the patient must exist. That's the standard of care. That's the contract. I am coming to you for you to provide a service to me, right? And you should be competent, you should be following the standard of care, all right? The second criteria is that breach of duty occurred. The standard of care was not provided. There was a violation. It wasn't provided correctly, or it was provided by an incompetent person. So you have the contract. You have what the implied, what you're supposed to do for me, and they say that you didn't do it for you. So these are the 2 things. The third part is that there's foreseeability of harm. It means the nurse must have had the knowledge or the availability of information that by not meeting that standard of care could result in harm. By not administering this treatment, could this pressure area get worse? You know, and when you're looking at it in the grand scheme of things, and this is where I say nurses tend, I miss one treatment. One treatment, is that going to hurt this person by not getting this one thing at this given time? It depends. You know, we know that pressure ulcers can develop within 2 hours. So by not turning and repositioning someone, there could be a direct harm. We know that. So that's the other. Then it has to be directly related to the harm. The standard of care that was not provided has to be directly related to that harm. So for instance, if somebody says that my loved one didn't come in to the nursing facility with any skin impairment, and now they have a stage 4, I'm going to tell you, say that you were negligent, right? Why were you negligent? Because I noticed that the same treatment was on, the same dressing was on there for 7 days, and I didn't see my loved one being turned in reposition, right? And I know that by not doing these things, a pressure ulcer can exist, right? Direct cause and effect. By not turning and repositioning someone, even though I know that they haven't been turned and repositioned, and my loved one falls on the floor and fractures their hip, is that a cause and effect? Not necessarily. Not by them not being turned in position did that cause them to fall. So it has to be, whatever that standard of care is, has to be directly related to the actual harm that occurred. And that harm has to have occurred by the individual, the plaintiff. Whoever's saying that the harm occurred, it has to be by their plaintiff, that plaintiff. We see this in pain and suffering. For instance, I sat and watched my loved one in pain and suffering after their fractured hip, and they fell in your facility, and I'm suing you for me. It was not directly done to me, kind of thing. Does that make sense? Okay. Any questions so far? Okay. When we're going, the one thing I did want to talk to too is when we're looking at these negligent things, and is the nurse individually held responsible? Where does your responsibility come in as an individual nurse? A lot of that has to do with a couple of things. We talked about the standard of care. So who's a person going to come after first is the facility. Typically the facility is going to be the first line of having to defend themselves. When you're looking at it from a facility perspective, the facility is responsible to make sure that their policies and procedures are in accordance with regulations and the current standard of practice. Right? If your facility meets those things, that they are, their standard of care, this policy and procedure and pressure also management is according to the standard of care, current standard of practice. If you as an individual nurse does not follow the facility's policy and procedure, that is when you individually can be held responsible. So it's very important to understand what your facility's policies and procedures are. And there's two things. It means that you have to follow the facility's policy and procedure. There's no choice about it. The only time that you don't have to follow the facility's policy and procedure is if you read that policy and procedure and you have information that says that it's not to the current standard of practice. So for instance, if I ask to see your wound care policy and procedure and it still mentioned heat lamps in it, then the facility is going to be held liable. Does that make sense? So it's really important to understand and follow policies and procedures. Talk about delegation. Delegation is part of the scope of practice for RNs. That is specifically within their scope of practice. Now, an RN may direct the LPN to delegate to an unlicensed healthcare provider. So, and your policies and procedures as a DON, typically there is a designation of who's responsible and who can delegate what. So you usually have a nursing supervisor who is the authority. They can delegate to someone. All right. Couple of things that we have to remember when we are delegating. You always have to abide by the standard of delegation. You cannot delegate something that you yourself don't have. Right? So I am an RM with the BSN, so I can pretty well delegate a lot of things. As an STNA, you can't delegate anything, all right? Because you can't. LPN can delegate to a nursing assistant, and RN can delegate to a nursing assistant. So you know what the chain of command is, and that should be outlined for you as to where does it fall, okay? You always, when you are delegating, you always have to make sure that it's within the scope of practice of who you are delegating it to. So knowing if you're to do an IV, make sure that you're IV certified. So you cannot, what we call self-delegate. If I delegate something to you, you don't do part of it and then give it to somebody, somebody else does the other part, somebody else. You can't. You take the whole thing. It's the whole component of the delegation. If you if I come and delegate something to you, you can then not release it to someone else. If you can't do what I'm asking you to do, whether you don't have time or you don't feel confident in it, and we'll talk about that, then you need to come back to me and say, I cannot perform this task, and this is why. Right? Even though it was within your scope of practice. I always say, I've been a nurse since 1988. I was taught, and it is within my scope of practice, to do tracheostomy care. I cannot honestly tell you when the last time I performed tracheostomy care. So if I was working in a clinical setting and it was my responsibility to do tracheostomy care, I would have to go to someone and say, I cannot do that. Not because it's in my scope of practice, it's because I don't feel incompetent, right? So you have the opportunity to refuse to do something by stating it's not within your scope of practice, or that your skills are out the window. Doesn't mean then that that person comes back and says, I'll show you how to do it, I'll make sure you're competent in it before you do it. So anything that you delegate, the person you're delegating to, they must have a clear understanding of what the expectation is, of what they are supposed to do. All right? It's also then our responsibility to make sure that it happens. And if we do not make sure that it happens, if we don't oversee that process, if we don't monitor, then we can be held responsible for their actions. Case being in point, I always like to say, for a nursing assistant, it's within their scope of practice to turn and reposition. It's within their scope of practice to provide incontinence care. All of those things are within their scope of practice. We have a resident that has a stage 2 pressure area, okay? So I know as a nurse, my care plan is saying that this person needs to be turned every hour on the hour. They need to have their air mattress. They need to have all of these things in. You tell the nursing assistant that this is the expectation. They verbalize understanding. If at the end of the 8 hours, the oncoming nurse comes in and says, this person hasn't been turned all day, or they were soiled, the last time their brief was timed was at 8 a.m. this morning, something like that, who's going to be held responsible? Both you as an individual nurse for delegating that task and the individual nursing assistant. If you went in and oversee to make sure that that nursing assistant was doing their job, and they did it, and harm still came of it, you're not, that's the component that you need to understand. And if they're not doing the job, if they're not competent in it, it is our requirement not to just say, okay, it's the DON's responsibility to educate. It's not. It's our individual responsibility to make sure that they understand what they're supposed to do and that we teach them the right way to do things. Or you get your staff development person involved. So being careful about that. Medication administration, we did have this question come up this morning, so I think it's best to reiterate it. Remember, medication administration is not eligible to a nursing assistant. It is outside of their scope of practice. I think they may mention that apparently a resident refuses to take it from a nurse and only wants to take it from a nursing assistant. You cannot do that. That is illegal. It's not eligible. So make sure that that nurse is responsible for administering the medications. Okay, we've kind of talked about that. The last thing that I kind of want to go over is the fact of nursing supervision. It kind of says the same thing. When you are supervising, that's what you're doing. You're overseeing. You're taking on that responsibility to make sure that everyone understands what the expectation is, and to ensure that that the expectation is achieved. So, and making sure that, again, if somebody's not doing what they're supposed to do, it's your responsibility to correct the situation by going through the reporting chains of command or whatever you need, whatever your policy and procedure is. Some of the other things that I want to talk about is mandatory requirements. What are we required to report to the Ohio Board of Nursing? The first and foremost thing is that we are required to make sure that a report that somebody doesn't have a current valid license. Now you think, oh, well, everybody has a current valid license. Well, that's not always the case. From a facility point of view, when you are hired, the facility validates that you have a current license to practice in the state of Ohio, and with or without restrictions, and that's up to them to decide if they hire you or not. But that's the thing. And then thereafter, they're also required to make sure that you have a current valid license. For instance, our RNs, this license expires on August 31st of 2015. If you do not renew your license on September 1st, you no longer have a valid license. So if you're practicing as a nurse on September 1st, you are illegal. And if anybody knows that, they're supposed to report it. Right? So that's, or if, you know, there have been times where I've seen nurses, their numbers have gotten, somebody else is using somebody else's nursing number. So protect your nursing license number. That's why they don't issue cards anymore, is because as an industry, we saw that people, when they could go online, turn a card off, and they were using somebody else's nursing license number. So protect that with everything you have. But if you know somebody doesn't have a current license, you're obligated to report that. Some of the other things that you need to is that if you believe that there's a problem with a nurse, you have to ask yourself if the nurse's practice or behavior is unsafe in any way. If they come to work and they are unsafe in any way, maybe they don't use proper techniques, they're incompetent in their skills, whatever, you are obligated to report that. If they are, what I say, medically or physically incompetent, they're impaired. They physically can no longer do, a safe job in delivery of services. Medically, as we do age, we do get forgetful. So if somebody who has had a license for 50 years does not mean that they are still mentally competent to be able to perform the duties. They still have to know the knowledge base of what they're doing. The impairment of drugs or alcohol. Making sure that if somebody comes and you feel that they have alcohol in their breath or they are impaired, whether it's prescription drugs or illegal drugs, and you feel like there's an impairment, you're obligated to report that. We talk in drug diversion, that's an obligation to report. When you're looking at reporting, I always say look at your chain of command. You as an individual can go right to the Ohio Board of Nursing. No one's stopping you from doing that. What we do though is we ask it's just like an abuse situation. What are you doing immediately to keep your residents safe? So if you feel that there's a nurse working with you at any point in time, you need to know who to report it to, and that's whatever your chain of command is. And that's usually outlined by your supervisor who goes and reports it to the DON, who reports it, and then takes the necessary steps to remove them and then to proceed with the investigation. Always judge, even if you have an inkling, judge on the side of you possibly could be wrong, and I will ask forgiveness but if you have some really significant observation or assessment, use the same observation and assessment that you're using for your residents to identify your coworkers. As nurses, I've been there and I've done it, that, they're just having a bad day, they're having an off day, they just are too tired to work, something, and you kind of make excuses for them. It will get you into trouble, because if you're not reporting it and something happens and you are aware of it, you're just as guilty. All right, so be very cognizant of that. Every complaint that is given to the Ohio Board of Nursing is investigated. It is, nothing, no matter how ludicrous it sounds, everything is investigated. All investigations are kept confidential. The only time that it becomes public knowledge is if the board found you guilty of whatever the complaint was. If that was a substantiated complaint and discipline was involved, then it becomes public knowledge. Because trust me, if public knowledge was for every case or every complaint that was put on to me, there would be several of them. The reason being, I was a DON for 10 years. And as a DON, if I pissed somebody off, to be quite honest, if I terminated someone and they didn't like it, I would have the Ohio Board, I could tell, Ohio Board of Nursing calling me, asking me for my side. This is my complaint. What do you have to say about it? You get a chance to defend yourself. Based on the information that's shared by both parties, will determine whether they then further investigate. But you know, again, if they decide to take it further, it doesn't mean that you're going to be found, it's going to be substantiated, they just need more information. And you get your due day in court. You get to go and you testify and you tell them this is my information and this is what I have. So from a Ohio Board of Nursing kind of standpoint, also from a litigation or from a lawyer, the one thing that you have to stand on to support yourself is your documentation. So always, always document the care and services you provided. Make sure that you're following the nursing process. When it comes to if you suspect somebody for, reporting to the Ohio Board of Nursing, I always say document the facts that brought you to the conclusion that you thought somebody was not safe practicing. Those are observable facts, being objective with that information. That's what they're going to look at. That's what they're going to want. So that's the complaint process. Any questions? No? Make sense? Okay. All right. All I need is to make sure everybody's signed in on my sheet for contact hours. Fill out an evaluation sheet. If you can just put them together, and I will fill out your I'll give you your certificates, and I will get out of your way because I think you have more information for them.